The topic is management of joint stock companies. The basic idea of the company working is to ensure the functioning of the company in a democratic manner. Board of Directors is the ultimate executive authority in the company. On the analogy of the representative form of government, management, they are elected representatives of shareholders. Management by such representative body is responsible to the electorate, that is shareholders. It gives the color of democratic administration in the management of joint stock companies. The board of directors is responsible to the shareholders. Actions taken by the board are based on the majority of decisions or decision of the representative body elected by the shareholders. Hence, the management is considered to be similar to that of the administration of the political unit of representative form of government. The incorporation is the unit with the memorandum and articles as its constitution, general meeting of the company and the legislature, articles of association and the legislative enactment, and the board of directors, the cabinet, which is responsible to the shareholders. Democratic principle is thus enacted to operate in the management of joint stock companies. With the diffusion of ownership, a franchise is extended. The greater the diffusion, the greater is the scope and chance for people with knowledge and abilities to join together, develop the right type of the business unit and provide an efficient system of the organization. But much depends upon the electorate, the shareholders. They must exercise due care in electing their representatives or the members of the board of directors. They must know their rights and possess the abilities to exercise them intelligently. In the absence of this, democratic type of the company degenerates into oligarchy or into fascism. Shareholders must always take an active part and intelligent. They must be perpetually vigilant about the activities of their government. Perpetual vigilance, it is the price of freedom. As Brooke said, it is worth noting in this connection too, the law in making provision for shareholders' control postulates effective cooperation as well as perpetual vigilance on the part of the shareholders. The lack of shareholders' interest in the maintenance of their rights is danger signal in democratic management. One should realize that the only safe depositories of rights of shareholders are the shareholders themselves. Various reasons, such cooperation and vigilance can hardly be expected. The result is that shareholders' control is becoming more and more a dead letter, and the character of management tends more and more oligarchic than democratic. So it is thus observed by Margaret Miller. On the question of shareholders' control, it is clear that the ideal of democracy upon which the joint stock company system founded is more honored in the breach than in observance. In running a democratic institution, members are always given some rights designed to exercise control over the management. These Companies Act has the Companies Act has given the shareholders such rights and more rights they had previously. They have increased rights as a result of the imposition of some limitations over the powers of the directors and managing agents as well. by direct increase of their own powers. This has the effect of enlarging the scope of control to be exercised by the shareholders on the management of the company, in which the opinion of CLC is one of the major aspects of company law reform in this country. Intelligent application of the rights will go a long way in making the directors very careful in the proper and efficient administration of the affairs of the company, in order that the powers given to the shareholders may be really useful and effective. A concerned action as opposite to individual action on their part, it is necessary. Concerted action, however, is difficult to achieve owing to the diffusion of capital ownership, apathy and ignorance of the shareholders. A critical examination of some of the powers will reveal their limitations as well as practical difficulty in their application. Appointment of the inspector for investigation may bring to light misdeeds of any member of the board or officers of the company and make cause of action to be taken to have a delinquent member or members punished in the court of law. This will have the moral effect of putting a check on the growth of fraudulent companies, as well as serving as a powerful weapon to check the activities of unscrupulous officers of the company. But such action, in addition to becoming a post-mortem examination, suffers from other serious drawbacks. It creates a suspiciousness and distrust in the shareholders, resentment in those in charge of the management. So it gives publicity to the occasional revelations of managerial incompetence and creates distrust, which attaches itself a good and bad business as a whole and undermines the confidence of the investing public. All this also requires a prolonged effort on the part of the shareholders. In addition, the procedure is laborious. If the shareholders do not care to attend the general meeting of the company, it can be expected that they will join together later and take concerned action in the matter. Of course, the same case may be whipped into the action over the grievances. Now, provisions of the Act relating to company accounts require a much greater amount of information to be included in the accounts than was hitherto given, have afforded the shareholders a great opportunity to know financial position of the company. The principle of disclosure is applied to require the presentation in the balance sheet and profit and loss account some additional items of the information as reveal the true financial position of the company and in the state of affairs as a going concern. A revised form of balance sheet has been prescribed in the Act, and the requirement as to profit and loss account are enumerated in the length or in the Schedule 6, Part 1 and 2 of the Act respectively. But lack of active interest and sufficient technical knowledge necessary to understand the accounts published by the company on the part of the shareholders make the matter a thing of pure academic interest. The other important privilege exercisable by the shareholders of a company is right they have in the appointment of the auditor of the company. It is through such audit that the shareholders can ensure that the accounts of the company are truly and faithfully represent the financial results of the working of the company. But in the absence of attendance by a large number of independent members at the annual general meeting of the company, the auditors cannot always be considered to be really independent enough, and they are supposed to do so. In many cases, a warning of the auditor comes too late and amounts to locking the stable after steed is stolen. Thank you.